Hey, good afternoon, everybody, however many of you are joining us today. And, the flocks of you who are going to join the recorded version of this special webinar. We're so glad. It's a great webinar today. We're going to go through some cases as usual. We've got 2 interviews instead of 1 interview. This is our CLA session of What's Up With Us. So let's kind of get started here and see what we have on our agenda as always. So first we're going to say, hey, what's up with Ashley? You see on the right side of your screen, it's me and JR are going to be the host. So Ashley couldn't make it today, and we'll get into what's up with Ashley in just a minute. We're going to talk about Romero. Then we're going to start our interview with Oyengo, the CEO of the California Lawyers Association. Another case, and then Jeremy, like I say, continuing our CLA session today, current president of the California Lawyers Association. And then another case that I thought kind of ties in a little bit of real property with a little bit of sports law. So I figured that would be great because we have Jeremy joining us today. And then instead of going through the activities, we're going to have a presenter, Mary Beth Height is going to present, and she's going to talk about the real property section, DEI panel or committee or something. She'll tell us all about that when we get towards the end. And just a reminder, hopefully you can join us next month, July 20th. But let's quickly go with, hey, what's going on with Ashley? Why is Ashley not here today? Ashley's not here today because she's busy packing. Why is she packing? Because Ashley has had it with California. She's going to Texas. She's going to so busy today. So what has Ashley done for this? Well, she's given up her West Coast swing and she's going to become a full-blown Texas two-step girl. No more suits for Ashley. Look at that nice, beautiful suit Ashley has on. No, Ashley's going to change and she's going to become a full-blown Texas cowgirl. And you can talk to Ashley more about that next month when she's back for the July What's Up With Us, and that's What's Up With Ashley. So JR may remember this, but a long time ago, I called her Ashley Montana because Ashley likes to vacation out in Montana. So I guess, that country cowboy stuff, that really fits her lifestyle a little bit. Okay, so that's What's Up With Us. Let's talk about what's up with some cases. And we're going to start with Romero versus, I'm not sure how to pronounce it, so I'll just say Shay. I'm not sure how to pronounce that last name. And so here we go, an appellate court case out of California. Kind of what happens when a lot line adjustment goes bad. And that's what this case is really sort of about. You had an original property owner who had 2 adjacent lots. Decided that one was a little bit too small and needed some space on the one. And so needed to take the space from the other one and had planned a lot line adjustment, adjusting the boundary by 8 feet along the full length of the property. Hired what appeared to be the appropriate people to get this done, but lo and behold, the adjustment was never finalized by the city. So the owner at that time gave the property that was supposed to be shortened to his son, who had co-owned it with somebody else and was going to develop it, and built a wall along where the property line wasn't going to be. Okay, so that on the son side was going to be 8 feet shorter, and on the parent side it was going to be 8 feet bigger. Okay, great. But no one really paid attention to the fact that the lot line adjustment was never finalized. The property was sold. Years later, the current owner of 651, which was the reduced property, or it was supposed to be the reduced property, discovered that the wall reduced the size of his property and access to a portion. Access to what portion? Access to the portion on the other side of the wall. That was fine. That's what he found out. He sued the current neighbor, Shay, and what happened? Shay countersued for implied and equitable easement. Well, of course, as this was going on, some other stuff happened. Romero's title company settled with Romero for $95,000 to settle the claim. So this case is really about the countersuit. And here's what happened here. At trial, the trial judge said, well, an implied easement really, in this case, would have recognized the original intent of the owners. And I don't know, it seems to me this was a real stretch here. And said, and the easement's not technically an exclusive easement because Romero would still have subsurface rights under that 8-foot strip. Who knows what they would do with those subsurface rights? And the trial court also said, you know what? For the equitable easement portion, we're balancing the equities. There was a lot of expenses and a great diminution in value to Shee's property.
Right.
Which did not have the 8-foot strip, and there was not really quite as much, some diminution, but not as much diminution for the Romero property because of the 8-foot strip. So the court said, you know what? We're going to award both an implied easement and an equitable easement, and lo and behold, you know, it's really not a permanent easement. Also because, heck, if they stop using the property for a driveway, a planter, and a wall fence, well, then it's going to revert back. It's like, who would stop using the wall, right? I mean, it's kind of like to me, it's kind of like a silly thing, but that's what the trial judge said.
So Neil, can you hear me?
Yeah, I can hear you. Go ahead.
Okay. I mean, this case is fascinating. I deal with this kind of thing all the time because what happens is like fences might be in the wrong place, or people put fences in the wrong place and then they leave them there for like 15 years.
Right.
And then, then they sell the house down the line. You're like 2 or 3 property owners down the line. And then all of a sudden people assume that that's their land. And when people want to move it back to the property line, it's always a dispute. And here, the big rule on prescriptive easements is exclusive use is not allowed, but this goes against that. And it basically says that, if you have real hardship on one side, like you said, diminution in value, the court might uphold an exclusive prescriptive easement. It's what it looks like to me.
So what you mentioned, JR, was what I was just about to get to. So the appellate court, went up to the appellate court. The appellate court said, guess what? You cannot have an exclusive implied easement.
Right.
But you can have an equitable easement. And I know when I first read this case, I was saying I did not distinguish between an exclusive implied easement and an exclusive prescriptive easement. So really there's kind of 3 things that could be talked about in this case, right? A prescriptive easement, and there's ample cases that said you absolutely cannot have an exclusive prescriptive easement.
Right.
Here, the claim was for an exclusive implied easement. I really didn't distinguish the two until I went back and reread the case, and I realized they're not talking about prescription, they're talking about implied. And the court seems to apply the prescriptive rule to an implied easement. But regardless, the court said, courts have great discretion to use their equitable powers, right?
Yeah.
And that kind of decision will not be overturned unless there was an abuse of discretion. The appellate court said there was not an abuse of discretion.
Yeah. Yeah.
So it all depends on your pleading, I guess.
It really is an interesting decision. I mean, it reminds me of the kind of things that Roger Bernhardt used to run through, where he would be like, this is the rule, but this is the 5 exceptions to the rules. And so basically the courts don't know how to rule on this.
Neil and JR, when I was looking at this case, I thought the appellate court was actually going to go the other way.
Yeah.
When you see language in an appellate opinion that says judicially created, sometimes you could be in trouble, right? It was judicially created at the trial court level, but us at the appellate court level might have a different analysis. So I was a little bit weary. I actually dealt with this personally in my personal life, not with a fence line, but with a structure in Washington, D.C. that was built about 2 or 3 feet over what the neighboring property said it should have been built.
Yeah.
But it happened 40 or 50 years before we bought the property. Nobody said anything, but the neighbor did complain about the gutters leaking when they weren't clean. So I needed her permission to go on the other side in her property, in her backyard, to clean the gutters out. And that was a nightmare. So
How did that work out for you, Yango?
Well, we didn't go to court, and I didn't end up like she or like Romero in this particular situation. So we just worked it out. She actually sold the property to someone who was a little bit more reasonable,
Yeah.
and then I booked it and came on with the California. So now my tenants are dealing with it. We're all good now.
That's cool. So for those of you who don't know, that's Oyango Snell. He's the CEO and Executive Director of California Lawyers Association. We're going to be interviewing him, and he and Jeremy Evans are on the line. They're both welcome to chime in anytime.
Well, JR, I was going to say, as Oyango was talking, I was thinking that it's too bad that this case came out in May of 2022, because I have a buddy in San Diego, actually used to be my barber down there, used to cut my hair, really nice guy. He had this beautiful home up in San Diego, and had this sort of large property, and part of the property was on a hill. And at the top, sort of maybe not the top of the hill, but about halfway up the hill, there was an easement, and there was a gate, and there was a sort of area where you could sort of walk back and forth. Well, unfortunately, the property line was drawn in the wrong area, maybe like 50 years prior,
Right.
before he even bought the home. And it turned into a ton of litigation. He spent a bunch of money. He eventually won, but that was after a lot of, let's say, childish activities in terms of trying to potentially move the fence line without telling anybody, or like actually at one point, he stuck skeletons on the fence, like Halloween skeletons, like, because I think he thought it was sort of funny or scary. I mean, the guy's a character, and both sides were, it was a pretty interesting situation, but this case probably would have helped him because I think the trespass was innocent. Clearly he didn't do it. Maybe his actions later were not innocent, but and then of course there was really no injury, because the property owner who was above didn't need access to that little area. But anyway, so such an interesting case, and glad to be with you guys and be on here with Oyango.
I'd be happy to have you. And you see, that was one of the factors, which is, how are you going to balance this equity? Who's really being hurt? Romero said, "Oh, I've got big plans, for this 8-foot strip," and the appellate court just saw right through that. Said that's all speculative. We're not really buying that. By the way, I see Mary Beth joined us, and so she may up in, or she may just save herself for her presentation at the end. We'll find out. Before I go, I made a little note there. Those who've been on What's Up before know I'm an attorney for the California Association of Realtors. And fortunately, the court here made some reference to the CAR forms. And I think they actually made an incorrect reference to our forms. The forms are something called a seller property questionnaire, which asks about a seller's awareness of certain issues, not whether those issues actually exist. And I think there was an incorrect reference to those forms in the opinion. Fortunately, it had nothing to do with the findings of the opinion or the holding of opinions. So I didn't have to get involved by writing some kind of brief to the court, asking them for a clarification. So that's it for Romero versus She. Let's turn it over to JR, who's going to do our first interview.
Hey, so Neil, I'm thinking about kind of mixing together Oyango and Jeremy. I think we got a lot to hear from both of these guys. So let me do a brief introduction here first, because if you don't know who Oyango Snell is, he's the CEO and Executive Director of CLA, our organization, California Lawyers Association. He joined us, I believe, in January 2022. So he's had about 6 months to and he didn't even get warmed up. He was hit the ground running, and it's been such a pleasure. There's a few things I want to touch on about you, Oyango. I just heard a little like blurb that you gave. It was like a little video, and the language that you use, I just think is especially effective. I really like to hear you use like phrases like "we got you." Only together can we do, finish these tasks and excel as an organization. And we are amping up our engagement. Things like that. I really like, to hear. And then combining you with my friend Jeremy over there is just the best of all worlds. I've admired Jeremy for a really long time. He's the president of CLA. And so it's really your leadership. It's really an honor and a pleasure to have you guys here. So, but I got a question for Oyango first. So I saw that you practiced law in Columbus, Ohio, which is where I'm from. And then when I learned that you were at least a Buckeye fan, that was a big deal for me. So you won me over right then. I was just like, forget about it. We're best friend forever. But are you actually from Ohio?
No, man. I grew up on the south side of Chicago.
That's right.
Yeah, I actually ventured over to Ohio after high school. My position coach, I played football in high school.
Okay.
I played football and I wrestled. My position coach, I was a defensive back. My position coach had made some connections, had some connections at Central State University in Wilberforce, Ohio. Vince Buck, a former New Orleans Saint, played for Central State. And my position coach, John White, he and Vince were friends. Reached out to Vince Buck, talked about getting me and several other cats from Chicago into Central State because we just probably wasn't going to college. So that happened, and I ended up in Ohio playing football at Central State University, a historically Black college, and had a great time, man. Had a great time. So that's how I got to Ohio.
So I am from Columbus, but you have to tell me where in the heck is Wilberforce? I have no idea where that is.
So if you're on 70, and you're headed to Cincinnati instead of Cleveland, so you're going south. Right. Before you get about an hour in, before you get to Cincinnati, and before you get to those outlets, you're gonna pass Xenia, Wilberforce, Cedarville. That area is where Central State is nestled in, right there in Wilberforce. It's actually two historically Black colleges over there. One's a university, and both of them are universities. You have Wilberforce University. Yeah. You have Central State University. Wilberforce University is a private institution, and Central State's a public institution.
Okay, so my next question is, so like when you're in Ohio, you're an Ohio State football fan. I know that. We don't want to bore everybody with that. But now that you're in California, you've lived in Sacramento for at least 5 years, I believe. So what's your sports focus now? I know you're a sports guy. What is it?
Yeah. It's you don't change the weather just because you went to another city, so to speak. You stay bred it where you are, even though the weather may be different around you, right? So I'm still a Buckeye fan, but I'm Chicago everything when it comes to professional sports, and I'm a Southside Cubs fan for life. Okay, that's cool. But so basketball, would you go Bulls instead of Kings? Yeah, absolutely. Every day, all day. Bulls, Bears, Cubs. Okay. End of story. You gotta love the Chicago spirit for sports and everything like that. But you also like boxing and BJJ too, right? I absolutely. I love UFC fighting. You can catch me every Saturday watching UFC. Love boxing. Grew up boxing a little bit. Some unorganized boxing, on street corners in the South Side of Chicago. Never had a sanctioned match, but I've won a few. I've lost many, but I've won a few. You don't have any problem with me boxing. I'll let you can just have the title. That's fine. I'm okay with that. I've met you, and so we're good with that. So the cool thing I realized about you is that you have both an MBA and a JD, and you're practicing lawyer, obviously. You were in DC and Ohio, and you're out here in California as well. So how does your MBA and your JD, for lack of a better way to put it, really lend yourself to lead CLA for us? It was really about understanding the language. Language is everything. That's what we do as lawyers. We learn how to write it. We learn how to speak it, right? So it was really about understanding the business vernacular and understanding our clients' interests, whether you were practicing law, lobbying, or running an organization. So put it this way, I had the opportunity to marry my association and business experience with my actual profession. Right. Not many people get to do that. Some people go to work, right? I do what I'm born to do, be a lawyer, represent lawyers, be part of this association, grow this association so that you all, our members, can become better practitioners, better members of society, And I think the combination of my experience, whether it was the association world, whether it was the business world, whether it was the education from an MBA or my legal training at The Ohio State University, Michael E. Morris College of Law, then all of that combined together in all seriousness really helps me at least understand the needs of our members. I was fortunate to serve at every capacity that one of our members could serve in. I've been at a major law firm. I've been in-house counsel. I've served as a government lawyer. I've been a lobbyist. And I even ran for politics. What all lawyers love to do, right?
I was just going to say that. And you ran for office. Yeah. Well, let me interject for a second. So one of the things I love about how you hit the ground running, and you are still running, it's not a jog. Jeremy might want to chime in on this because he and I have talked about this before. Jeremy and I love the entrepreneurial spirit. If there's anything that we love about like America and like just what's going on, and I think that that's one of the things that you really bring to CLA, and I'm excited about what's going on right now, is you kind of run it like, is it a startup? I wouldn't say that, but you run it like you have an agenda. You're moving forward in business. You're trying to win. Yeah. And it's exciting. I think it's really
it actually is a startup. So here's the gist of it. It's a startup, but then again, it's not. And I think this is where you were going. In short, and I shared this with our board, we've only been in existence as an association for 4.5, almost 5 years now. So with any organization, especially a nonprofit, when you look at the operations and the focal points in the first 5 years, it's usually investment in humans, investment in technology, investment in your governance, what you're going to look like as an organization, your core programming. Well, we had the luxury to rely on the experience of our section leaders coming from the state bar to the CLA, who've been developing program content for decades, who've been operating and governing, sections and our organizational components rather for decades. So we began operating at a mature level, even though we were still an adolescent when it comes to an organization. So thinking entrepreneurial is in our DNA as we begin to right size our staff, right size our core programs, our governance, so that we can take this association to the next level.
I think that's great. I'm really excited. Like Jeremy and I, during that wellness weekend where you were, we were in, for those of you who don't know, in April, we had a wellness weekend. It was a combination of CLEs and actual wellness stuff. Oyanga was there, Jeremy was there, Neil was there.
Yeah, Neil was there. Mary Beth was there.
And it was a great event. It was super. I mean, just the energy of having you there was really great. I can't wait until we have our ledge days again with you at the helm. I think that's going to be a lot of fun. So, yeah. All right. So I got another personal question, and then I got a hard question, and then we're going to do some Jeremy, if that's all right, Neil.
Absolutely.
Okay. All right. So tell me about the last piece of furniture that you built. I heard you like building furniture.
I'm glad you said the last piece of furniture that I actually built rather than the ones that are on the list to build. If you ask my wife, the list on the latter is longer than the former. What was the last piece? So the last piece that I actually did, I recalibrate or redone a coffee table. So I built a coffee table. It had a wooden box frame. Mm-hmm. So the frame was made out of 2x12s. And then the top was made out of plywood, and I put some strips along the side. So I did two projects at the same time. So I'll tell you one really quickly. So I recalibrated this coffee table to look like a cement coffee table by doing a feather faux finish of cement rather than having a big block, which would be heavy. And the wife, when I'm not around, wouldn't be able to move it. My son, who's 7, helped me actually build our dining table, our kitchenette table. It's a nice little square table. We put some little accents on it, and he's very proud that he helped do that. So those are the two pieces that we've done simultaneously.
All right. So we're going to transition. I get messages that I'm taking too much time, and I literally could go another hour with you because you're just fascinating in all respects. Okay, so I had a question from the people attending, and it was I'm going to ask you first, and then I'm going to transition to Jeremy. So Jeremy, be ready with your answer. So, what is your favorite bourbon, Oyango?
Oh, you can't. Woodford Reserve, but give me a rye.
Mm-hmm. Mm-hmm. Yeah,
there it is.
Really good.
with a large cube with an orange peel.
Yeah, I remember that. I
That's
remember
it.
that. Yeah, all day long. Pretty much all rye can be drank just like that, and it's a beautiful experience. It really is. So yeah, I'm right there with you. So there you go, Ash. You got your answer. Now, Jeremy, I think you might. I'm not sure you're a bourbon guy, but what's your favorite bourbon?
Buffalo Trace.
Buffalo Trace. That's a good one. That's a
Yeah.
really good one.
Yeah.
So
absolutely.
that whole family is good right there.
Absolutely. No, it's bourbon is a terrific drink. And you know, I don't know, Yango and I have had a few nights and a few discussions with that. So you know, it's awesome to be here with you guys.
Yeah, no, it really is. So, okay, you're the president of CLA, and I remember. I'm just going to do a little introduction here because you were the representative and the executive committee for CLA for a solo small firm, and then you run a California sports lawyer, right? And so you represent athletes and do various contracts for entertainment venues and things like that, right?
Yeah, so I started California Sports Lawyer about 10 years ago. And when I started it, I initially wanted to be a district attorney. And when I worked for the public defender and worked for the court, I realized that that was not the path I wanted to go down. And I went back to what my passions were growing up, was playing baseball and being in sports, and growing up in sort of Hollywood, Los Angeles area. I had a passion for entertainment, you know, film and television. And I, you know, at the time, you know, often as the saying would say, if you knew all the challenges you were going to face, you probably wouldn't have done it. And so, but I jumped headfirst in and said, not only am I going to start my own practice, I'm going to start it in the most difficult arena to do it in, entertainment and sports. But yeah, I represent and work with studios. I've worked with advertising agencies. I've worked with talent. I've worked with baseball players, worked with a lot of agencies. I've had some models, some very interesting clients. And it's sort of one little antidote really quick, JR, is when I started the practice, California Sports Lawyer, I didn't want to start something that was like law offices of Jeremy Evans, you know, law offices or Evans Law Group, because I thought everybody does that, right? Which is nothing wrong with that. It's a good description. It says who you are and all that. But I thought, what is the Google search term for a lawyer who practices sports law in California? And I thought somebody had to have trademarked this. And so I was like, well, I looked it up. It had not been trademarked. And so I trademarked it. And I would say it's helped a little bit from like a marketing standpoint. But I think more importantly, it's been a cool brand to build. And I love doing it, to your point, and Oyanga's point about entrepreneurship. And I think having Oyango and I at the helm, in that sense, at this stage of the organization is really the perfect marriage.
No, it's like that wave and you're just about to catch it. And we're going to have a really nice ride right now. I'm really looking forward to it. Okay, so personal question, Jeremy. Since you were one of 9 kids, how did you ever get a square meal as a kid?
Oh man, you got to be feisty. You know, you got to learn how to fight for your meals. I will say this. I was always a social kid. You know, I loved people, loved being around people, but I became even more social because, you know, 9 kids, your parents are working, resources are limited. I would say our family was probably, I don't know, lower middle class, maybe even, I mean, my parents would hate for me to say this, but probably even below that. You know, resources were limited with 9 kids, and we're all 1 year apart. So, you know, my oldest sister is only, you know, 10 years older than me.
Wow.
So socially, I went out in the neighborhood to get fed. So I would literally go to friends' houses and say, hey, how you doing? And just hang out. And then it'd be like the mom and dad would be like, hey, come in and have dinner with us. And I would say, that's great. You know, that's what I was looking for. So it worked out.
Yeah, that's just what my stepbrother used to do all the time. He used to show up when dinner was being served. So good job there.
Thanks.
Okay, so here's another one. Which was more fun, Nice, France, or Zhejiang, China? Did I pronounce that correctly?
Is it Hangzhou, China?
Hangzhou, but the town I thought was called, the region was called Zhejiang or something.
Yeah,
like that.
I think you're right. It's so those are two study abroad programs I did in law school. Man, that's a good question. I would say with Hangzhou, China, that was my first time ever leaving the country. So I had only been, I mean, I've been across the border into Mexico a couple of times, but in terms of like flying and being in a sort of new country, China was my first experience. I will tell you, there was one day of sunshine the 40 days I was there, because the smog was pretty bad. Crazy foods, great experience I had. We were at a karaoke bar, and I'll never forget, a couple local Chinese gentlemen were singing Hotel California by the Eagles. And I just remembering how good they were at singing that song.
Yeah.
And I thought, how fantastic is this? I'm halfway across the world and these guys are singing Hotel California better than potentially the Eagles. So that was fun. But I would say Nice was great in the sense that we had little apartments right on the beach. And you have this perfect marriage between Italian food and French food there.
Yeah.
And the Formula One race was going on at the time in Monaco.
Okay.
We took out a boat out to Antibes, the sort of famous island out there. Of course, the film festival's going on at Cannes. It was fantastic.
Wow. Like, every time I turn around, you're living the life. I'm always have so much fun listening to your story. So again, I want to reemphasize to everybody, both Oyango and Jeremy, tremendous entrepreneurs themselves. They're running our organization like that. California is an enormous place. And so we're really counting on your leadership it's a tall task. So one thing I really admire about the state of Ohio, Yango, is that they always have a balanced budget. They always run their government so well. California is a lot more complex. People might complain about how it's running everything, but I don't even think that I mean, it just means that the task is that much harder. So I'm going to ask you both one difficult question. And the reason I'm asking you is because our group has faced the same question and we don't have a good answer yet. But I think as a group, I'd really like to try to tackle this. So I'm going to ask you, what do we do to invigorate and engage more African Americans into our field, and more Latinos, especially Mexican Americans, into our field? Again, we've gone around and around about how to do it. And I mean, it's a tall task, but it needs to be done. It's severely underrepresentation by those groups. So I'll go with Oyango first, and then we'll go to Jeremy. Just want to hear what you guys have to say.
Yeah, I appreciate the question. This may sound cliche-ish, but the first thing you need to do is do exactly what you just did. Start asking the question.
Yeah.
That's the first step, to start asking the question. We recognize the issue. We recognize that our deficiencies as far as having a diverse composition within our association, within our field, and there's plenty for us to do. There's no silver bullet, though. Let me go on the record and saying that there's no silver bullet. There is no one thing that we can do to help increase diversity. There's probably many things that we can do, but there's no one specific thing. Different races, different individuals of different sexual orientations, different generations. Diversity is bigger than just race. It's also generational. It's also thought, abilities, and different things of that nature. So the first thing to do is to ask the question, but then to think broader about the question as to what it is that we should be considering and how do we go about making intentional efforts to do just that. Now, after we've gotten past those preliminary components, it's really about looking at our policies, as well as looking at whether or not we're creating inadvertently, or in some cases intentionally, burdens for people to enter our field, whether it's law school and the law school admissions test, whether it's the bar exam. Jeremy's on the commission. He can talk about that with the state of California and what they're looking at. But it's a number of different things. Here's a reality that we need to wrestle with. You can't go pluck an attorney off the streets and say, or a person off the streets rather, and say, join our legal field. It doesn't work like that because of the training that's required in order to become an attorney. The reality of it is that we have to invest as an industry in those that come after us, the pathway to becoming an attorney, which means that we're not going to see the significant changes, the significant results in our professional lifetime, but our work is required to lay the foundation. And because we want to see immediate microwave results, remember we used to criticize younger generations of wanting to see microwave results. The reality of it is that we need to do the work for future generations to actually realize the work of a true diverse field, because it's not going to happen overnight.
Pay forward. Jeremy?
Exactly.
Yeah, no, and I love what Oyango said, and I'll focus on a couple of things. One is what Oyango and I have been doing. We've been traveling around the state, meeting with affinity bar associations, connecting with other lawyers, making ourselves available to folks to let them know that we're here and we're the bar association for all attorneys. That's been our mission from day one, and we're acting on that by going out and meeting with people, attending their events, spending money at their events, being engaged, looking for ways to coordinate on events. We're doing this great gala in San Diego. First time we've ever done a statewide gala. We're inviting everybody to attend. We're highlighting local bar associations. I think that's sort of a big idea of what we're doing. We're encouraging people. I mean, our whole mission is to increase membership. And yeah, you could say that, you know, that's a financial gain and to grow the organization. But it's also about really delivering on the mission of, we really do need to represent all of California lawyers. I mean, that's why the legislature split us off from the state bar, was to do that work, right? I think the second piece to that, to Oyango's point, is I serve on the Blue Ribbon Commission for the Future of the Bar Exam. It's a 19-member commission appointed by the California Supreme Court. It's an honor to serve on this group. And one of the things that we've been talking about is creating sort of a new or revised exam. So as everybody knows, back in October of 2020, the exam was basically made online for that particular time, or September, whatever the date was. I think it might've been October. And it was made online, and they lowered the cut score. And then prior to that, they actually reduced the test from 3 days to 2 days. And it wasn't that the results changed as much, at least the data didn't suggest that. I think the October exam by far was one of the higher passage rates. But I think it was more getting to the point of, how do we make this test more fair and equitable, right? So that was sort of the initial changes. What we're looking at now is, how do we change the structure of the exam from what's included in there? So for example, I've been a big proponent of moving away from a lot of the memorization pieces, which frankly, you know, when you're an attorney, you're not, very rarely you're going to memorize, you know, some law or some provision. You might, if you deal with it all the time, of course, but most of the time you're going to go to the library, you're going to have LexisNexis, you're going to have a standard template contract, you're going to ask a colleague, you're going to work with a friend. I mean, that's what lawyering is all about, right? Especially as a solo or as a small firm, even in a firm setting, you're going to ask your colleagues. So, and then of course, when we look at what's most important for a lawyer, obviously competence is important, but so is ethics, so is civility, so is the ability to negotiate a good contract. So what we're trying to do is implement some of those things in the next bar exam, assuming the California Supreme Court approves of the changes, which I think would make the test more fair and equitable, because it would take it away from memorization, take it away from an endurance test, take it away from the sort of idea that we pride ourselves in sort of low passage rates. I don't think that's something we should necessarily be proud of. I think we should be proud of being an engaging community in training good lawyers. So again, I think some of these pieces are going towards, let's make the test more fair and equitable. And I think that probably starts in the law schools. It starts with some training. It starts with sort of providing, you know, that pathway to education, so they eventually take the exam and they're ready and prepared for it. You know, I will tell you that I did not pass the bar exam the first time. I missed passing by maybe 1 or 2 points. But you know, I sort of took the approach of, I'm not going to, what's the sort of the definition of insanity, is do the same thing twice and expect different results. So I knew I couldn't study harder. I said, that's not the problem. The problem is, how do I pass this test? And sort of, I consulted with some colleagues and that sort of thing, and got to a place where I needed to be. But those are some of the things we're working on. Obviously, this is important to us. We want to make sure, and Oyango and I have really been sort of, there was a comment in the chat about the dream team. I think for me, I love working with Oyango. We are truly like really good friends, and we plan to be friends for a long time. And for the rest of our lives, and maybe even after that, we'll see what happens.
It depends on where we go.
Yeah, that's right, brother. So, but that's where we're at. We love the CLA. We love the members. I mean, for example, JR, we were up there with you in Lake Tahoe at your guys' retreat. I mean, it was such an inclusive, like nice environment to connect and to, kind of take a step back and say what's important in life. And really the gala and all these things that we're doing, it's all about, this is the last thing I'll say, I've talked too much, is it's all about connecting with people. And we also need to celebrate the profession. We have some great lawyers. We have some great people. We need to do our job to celebrate what we do. I tell you, one of the first things I get from people all the time is when you run across somebody who's not a lawyer, is they will say one of two things to you. Hey man, I got a lawyer joke for you. That's the first thing. It's just fun. I'm a good, fun-loving guy. All right, whatever. That's cool. And then sort of the next thing is like, hey man, I got a legal problem. Can you help me solve it? And I guess doctors get the same thing, but we're just trying to create a good community. We're trying to do that by action, and just being out there and being welcoming to people. So I think that's important.
No, well, thank you so much for being here, both of you. It's a real honor to have you. It's a dream team. So Tara Bird, who's part of our group, as you know, like reports back with us. She also loves working with both of you and what you're moving forward to. But I'm going to turn it back over to Neil. Thank you both. Again, true honor. So I will be seeing you. I think I'm buying tickets to that darn gala now. I got to go get mine.
Got to, man. Got to. It's going to be one to remember.
Absolutely. Just don't be getting a velvet tuxedo coat, because Oyango and I got that locked in already.
Oh, all right. I mean, I like to look kind of like Dumb and Dumber, where I have like the blue thing on.
There you go.
All right, guys.
All right, well, thank you, JR. Thank you, Oyango. Thank you, Jeremy. Great stuff. Hey, Jeremy, maybe you could put in the chat, I just put down for your bio information, CEO, and I think I remember reading it that it stands for something a little bit unusual, not what anybody would think of what CEO means. So maybe put that in the chat. So let's quickly talk about our second case, Gukowskian versus Aegis Security. Kind of interesting case. One neighbor decides to start leveling land that the neighbor thinks is hers and cut down some trees, and lo and behold finds out that they're doing this on the neighbor's land. So it sounds a little bit like Oyango's situation earlier that he talked about. Of course, the neighbor wasn't too happy about that, right? And the neighbor sued for trespass and negligence. The plaintiff tendered to the insurance carrier, and what do insurance carriers always do? They always deny, claims. But in this case, the insurance carrier said, well, wait a minute, this is just not a covered action. What's covered under the policy are accidental actions. This was not accidental. The action was intentional. The legal consequence was accidental. The legal consequence was not intended. The person who did the cutting thought they were cutting on their own property, but they knew that they were cutting. They were planning on doing cutting. They were planning on doing the leveling. And this case, the trial court granted the summary judgment brought by the insurance company. The appellate court upheld the decision of the trial court. So it was really kind of interesting distinguishing between was the act done intentionally versus was the consequence of the act something that was intentional. And I like that the court gave, the appellate decision gave an example that I kind of took some liberty with, which is, so let's say the original person was cutting the tree on the neighbor's property, hired a service cutting a tree, cuts a limb, the limb falls down and crashes through the neighbor's house. That action might have been covered because there was never an intention to drop a limb on the neighbor's house, right? The intention was to properly cut trees. So the negligent act, the accidental act of having it fall on the neighbor's house, that might have been a covered occurrence. Whereas This one wasn't. Real quickly, I put down this was my favorite case this month. Why? Because it was only 8 pages, and there's nothing I love better than short cases. Anybody want to add something here? I guess not, so let's move on. Okay.
Well, I was going to say, I had a buddy in San Diego that, I mean, there's a lot of property issues when I was in San Diego, but I had a buddy that would distinguish his house by saying that that certain tree was in his yard. So in his signature, and he worked from home, so his signature line would say the big oak tree in the yard. And it was like, that was how you knew where he lived. I only bring it up because trees can be really important in terms of people's homes and what they find to be precious or whatnot. But interesting case.
Neil, I literally laughed out loud when I read that this was your favorite case, not because it was short, because I'm like you. I loved short cases, especially 2 to 3 page cases. I really love those. But if we were in person, this is where I would have a furry joke, as in a fir tree, not necessarily furry, but it doesn't quite stick the landing when you're virtual, be that as it may. You got to know your tree line, man. That's what this case really told us. You got to know your tree line. Mistakes be damn. Know your tree.
So we're really helping JR out here today with cases that are right up his alley and right up his practice. And JR, hopefully you'll use these going forward. And let's quickly get through our last case, Mays versus La Sierra. And this is a case which is, hey, does primary assumption of risk apply to an attendee at a baseball game? And in this case, the baseball game was a college game. It was a championship game. The plaintiff, Mays, was there to watch her son, who was teaching pitching, excuse me, for the opposing team. There were very limited seats behind home plate, which was the only area that was protected that had nettings. She was sitting off on a grassy knoll, sort of on the third base side of the field, and it was struck and apparently seriously injured, which was really too bad. The trial court said, this is just a classic case. Primary assumption of risk. You go to a baseball game, there's a chance you're going to get hit by a foul ball. That's just part of the nature of going to a baseball game. The appellate court reversed the decision and said, well, wait a minute, sports venues have a duty to take reasonable steps or measures to protect spectator safety. And he said, well, Mays raised a number of issues that maybe the venue could have taken, and that this issue should go to the jury, as opposed to being granted on a motion for summary judgment. So what to me was kind of most interesting here is that one of the issues was that there was distractions where Mays happened to be seating, people had umbrellas, people had tents, you couldn't always see what was going on in the field. And it makes me think about today's stadiums. The actual game is just almost like a minor issue when someone goes to a modern stadium today, right? There's fireworks, there's huge jumbotron, there's people yelling, trying to sell you, sodas or popcorn or whatever. Everybody has Wi-Fi, everybody's checking their sports betting, at everything that's going on. It's like, is anybody really there to watch the game? They've got, great venues for food. They've got, valet service, somebody will bring food towards you. It's like, really, is there even a game? Is anybody there to watch the game anymore? So there's a whole lot of those issues that I think are relevant in today's field. I'll start with Jeremy. Maybe you've got something, to add to this about, what you think, given your sports practice.
So thank you. And JR and Neil, you guys have been fantastic. And thanks for having us on. I actually just put an article in the chat that I wrote on this a couple years ago, entitled Netting the Foul Ball Problem. And this is such an interesting situation because in Japan, for example, there's nets around the entire stadium, even in the outfield. And a lot of times those nets will catch home runs or what have you. There's been a phenomenon. I think I'm a big analytics guy in sports, and there's a few things that are happening in terms of why baseball changed its approach to adding sort of these nets that used to just be behind the plate, and now they extend basically all the way down to the foul poles. Number one, pitchers are throwing harder than they ever have before. That increases higher velocity off the foul balls. Interestingly enough, foul ball territory has shrunk in its place. For example, I'm a big baseball enthusiast, and I love traveling around to the different stadiums. So I've been to 20 of the 30 so far. I'm trying to finish the other 10 this summer. And at PNC Park in Pittsburgh, is one of my favorite ballparks. As you sit behind the home plate, you are closer to the catcher than the pitcher is. So give you some perspective as to how close you are to the field. Foul balls have increased almost 12% since 1998, which batters have sort of attributed to the fact that pitchers are throwing harder. They're fouling off more fastballs, to sort of get to that point of getting something they can hit. I tell you, I've been at a Dodger game before where you have people with their radios in hand listening to Laker games, or they're listening to something else other than the baseball game. I've often, one of the ideas I put in this article was, should we treat seats at the ballpark like the exit rows in an airplane, where you basically say, you give the disclosure, if you're sitting in this seat, there's potential you might be hit. This is what's going to happen. Does that relieve liability? Probably not. I think the nets are probably here to stay. But as a baseball purist, it was kind of sad to see, because although you can still see the field, it is kind of weird when you're looking through a net, or you take a picture and it's just, but hey, when people aren't paying attention and they're checking their cell phones, to your point, Neil, and they're looking at things, it's tough. And you got to do something to protect people if they're not paying attention. So.
All right, well, thanks a lot, JR. Or
Yeah, I think a bit, Neil, you hit it on the head. Like, people at ball games are not paying attention like they used to. I used to see like half the crowd bring their glove so that they could catch a foul ball. Now it's like maybe 1 out of 60 people you see with a glove, and it's normally like a kid. So like, those balls are coming fast down the first baseline, third baseline. Like, it's dangerous. I just think it's interesting that this appellate decision did not say that the ballpark was liable. They just said it couldn't be decided on summary judgment, which I think is pretty interesting distinction. But again, yeah, is there possible liability there? The court's saying, yeah, there is. So Oyengo, I think, wants to say something.
I think the appellate court, from a legal perspective, it's being a legal purist, I think the appellate court did what it was supposed to do and didn't go further into the substance of the arguments. It did kind of give a little snide comment where we don't know if this could be meritorious or you'd win out on it, but it at least gets past summary judgment. This is one of those instances where who's in the better position to protect the public, and it's gonna usually always side with the ballpark rather than the individual. I know we don't like having systems have to protect us from ourselves in that big brother capacity, but in this particular instance, you got to look out for the public in the best way possible, and the ballpark or the owners or those individuals, the university in this particular instance, is in the best position to do that.
Well, thank you so much, guys. You know what, I'm going to quickly turn it over to Mary Beth. Yeah, I see you've unmuted yourself. If you want to see what's coming up, just look on your screen. Mary Beth, tell us about your role with the real property section, diversity, equity, and inclusion panel or committee or whatever. Tell us about it.
Sure. So, well, first off, though, I have to say that no one disclosed to me that there were going to be any Ohio State fans on this podcast today. I went to Wisconsin. Notice we don't say the University of Wisconsin. We just say Wisconsin or University of Wisconsin. I also went to USC for Jeremy. I just saw your Go Bruins thing. My favorite bourbon, if someone else is buying, is William LaRue Weller. So write that down. In terms of just kind of like my favorite everyday type of sipper is I like almost anything that's double oaked. So Woodford Reserve Double Oak, Nulu, if you're not familiar with it, nice little kind of micro distillery out of I think it's in Louisville.
Mary Beth, it sounds like you, me, and then there's a guy named Jeremy Olson in our group, not Jeremy, but Jeremy would also be included, but we're going to have to sit down and next time our group gets together.
Yeah, and I'm thinking actually we need to have some sort of bourbon fundraiser or something, maybe.
We've done that. Well,
Okay.
yeah.
All right. So, but back onto the business at hand. So I am the chair of what we call the DEI panel for the real property law section. It is a newer panel, and I took over as chair this past year. So right now I'm trying to kind of rebuild the panel, get some new folks on the panel, and start doing some really good planning for some activities, and perhaps some groups that we might be able to get involved with to help with mentoring, chatting with people at the grade school, middle school, high school level about legal careers. I know I'm the first lawyer in my family, and if I hadn't been exposed to the legal system in some fashion, I may not have known about that as a career opportunity. And I think that is something that a lot of folks that we need to bring into the fold are probably in the same position. So we're really just kind of looking at opening it up to anyone who's interested in joining us. It's very important work. It's very rewarding work. I promise we'll have fun. My email address is down there on the slide. I'm a partner at DTO Law. We have offices in LA, Redwood City, and we're soon to open a couple of more. So I'd love to have you guys involved. Anyone is interested, and if you know anyone that might be, send them my way.
Hey, sounds good. Thanks, Mary Beth. Right, you've got her, email address, mheight@dtolaw.com. We welcome everybody at the real property section, and anything we could do to, as I say, increase the goals that Oyango and Jeremy were talking about. Matter of fact, I'll just throw in one quick, side bit before we say goodbye. One thing is getting people interested and excited about the law. I happen to be a member of the LA County Bar Appellate Court section, and I have participated in a program for many years where we go to a high school, we talk about a case that's going up on appeal with high school students. We have them learn about the case, go see the oral argument, and talk to the justices that are deciding the case afterwards. So we're trying to get people interested at a younger age and think, hey, wait a minute, maybe I can do that. It's not just somebody on TV. It's something that I have the ability to do and to join in and be a part of and to influence decision-making throughout the state of California. So anyways, that's it for us. We're right here at 2 o'clock. I appreciate all of you joining us. It was really a great panel. We learned a whole lot about CLA, and you're right, JR, we could have gone for an hour without talking about any cases today, but maybe at another What's Up with Us. Thanks, everybody. Bye now.
Bye, everyone.
Appreciate